Thank you, Christoph, for the kind invitation to this conference and panel. And thanks, of course, for the much too nice introduction. Crisis is a concept around which our common thinking revolves. As we have heard in the morning by the convener of our gathering, global constitutionalism is in crisis. And international human rights are in crisis too. Yet, in the next couple of minutes, I do not want to deliver a eulogy of crisis. As you all know, the etymological root of crisis, the Greek word krinein, refers to the activity of reflecting, distinguishing, and judging. In that sense, times of crisis call for thorough reflection and sound decision-making. It is well plausible to claim that we stand at a critical juncture. Our next steps may be decisive for whether we preserve and promote the project of international human rights, or whether we fail to protect it against the great many risks and dangers it faces. In that sense, crisis promises to be an analytical lens fit for the occasion that brings us together. My eulogy is different, though. It is the eulogy of ambition. It takes me back to the 1990s. If you allow me this autobiographical remark, this was the period when I awaked intellectually, when I entered university, shockingly long time ago. This was a decade of ambition indeed for the International Human Rights Project, comparable only to the foundational period of this project in the second half of the 1940s. Hence, I would like to turn first to this period of human rights ambition. And I would like to contrast the 1990s with a number of subsequent developments that are commonly deemed to be debilitating or even destructive to the human rights agenda. This will serve as a background to identify and evaluate in the next step the current dynamics at play in the international human rights regime. And just to warn you in advance, I have 9 in mind, but I promise to be brief so that there will still be time for a short outlook. It is a truism that a global endeavor such as international human rights does not operate in a geopolitical vacuum. This was the case in 1945, when the Charter of the United Nations was adopted by the victorious powers of World War II to, quote, save succeeding generations from the scourge of war and to reaffirm faith in fundamental human rights, quote, end. The 1948 Universal Declaration of Human Rights was a joint answer to the experience of, quote, disregard and contempt for human rights having resulted in barbarous acts which have outraged the conscience of mankind, unquote. And the contemporaneous Genocide Convention, adopted only one day before the Universal Declaration, reflected the shared conviction that it was necessary, quote, to liberate mankind from such an odious scourge, end of quote. And then came the Cold War. Its end, let's mark it with the cutting through of the Iron Curtain by the foreign ministers of Austria and Hungary, in June 1989 in Klingenbach, Austria, Sopron, Hungary, less than 200 kilometers from here, the end of the Cold War heralded the advent of another formidable rise of the international human rights project. The disappearance of the antagonism between the West and the East augured to unleash dynamics towards a new age of human rights under the auspices of a benevolent hegemon in the West. Global human rights as a positive collateral effect of the Pax Americana. In the 1990s, a significant boost for international human rights could be observed in at least 4 dimensions. In terms of proliferation of human rights instruments, expansion of membership in them, strengthening institutional protection, and increasing cross-sectional impact. First, many new international human rights instruments were launched and adopted, seeking to extend particular protection, for instance, to children, persons with disabilities, and victims of enforced disappearance. Secondly, states heavily engaged in ratifying human rights conventions. This became particularly manifest for the European Convention on Human Rights, whose membership virtually doubled during the 1990s. Thirdly, notably in the wake of the Vienna World Conference on Human Rights in 1993, major developments in the international human rights protection system took place, notably the creation of the Office of the UN High Commissioner for Human Rights, as well as the replacement in 2006 of the Human Rights Commission by the Human Rights Council as the paramount human rights body within the UN system. In addition, the very creation of the International Criminal Court in 1998, with its mandate of combating impunity for the most serious crimes of concern to the humanity as a whole, of which we shall hear more shortly, deserves to be acknowledged as an additional layer of institutionally protecting human rights at the global level. Fourthly, and most interestingly, in terms of structural development, the 1990s represent the decade of international human rights spillover into other fields. This can be observed vertically in the reform of existing national constitutions or the creation of wholly new ones under the aegis of international human rights law. This also becomes manifest in a horizontal perspective in terms of cross-fertilization of other branches of international law, be it international criminal law, humanitarian law, environmental law, trade and investment law, and even general international law. The aforementioned 1993 World Conference on Human Rights, the 1995 Beijing Conference on Women, as well as the 2000 Millennium Declaration, stand for the call to mainstream human rights into all policy areas. In the legal context, the principle of systemic integration, as enshrined in Article 31(3)(c) of the Vienna Convention on the Law of Treaties, triggered in the name of regime interaction, the inclusion of human rights concerns in judicial and arbitral decision-making in fields that used to be considered remote from human rights protection. According to many scholars at the time, these achievements testified to an ongoing humanization of international law, representing the major building block in an even more momentous project of constitutionalization of international law. Such powerful cosmopolitan vision nourished hopes for the entrenchment of human rights, hand in hand with democracy and the rule of law, we have heard about that in the morning, into domestic constitutional theory and practice. Our situation today seems to be a far cry from the aspirations of a quarter of a century ago. Again, the geopolitical situation has markedly changed. The prediction of American unipolarism has long gone and has been replaced by the narratives of the rivalry of China in all relevant fields, the renaissance of Russia, as well as the rise of other major powers, to the detriment of the West and notably to Europe's relative share of global power. The dynamics unleashed by the end of the Cold War and its containing forces have given rise to secessionist movements, civil wars, and outright international wars in all four corners of the world, resulting in the breaking apart of existing states, situations of occupation, and the emergence of failed states. 9/11 and the ensuing war on terrorism have massively undermined the hopes that the 21st century will become a new era of cosmopolitanism and human rights. Let's see what the announced withdrawal of US and NATO troops from Afghanistan, quite tellingly scheduled for September 11 of this year, will bring. Having all this in mind, it is en vogue now to observe, or at least forecast, the end of the human rights age. This is the narrative of international human rights facing an existential crisis. But is this narrative convincing? Let me use the remainder of the time allotted to me to identify major current dynamics at play in the international human rights regime. As announced, I shall endeavor to cover the vast field lying before us by highlighting 9 developments out of the many that would deserve to be addressed. The number 9, 3 times 3, is of course meant to honor the deep symbolism of our event and its convener. So let me proceed by addressing in turn 3 transformations as regards the content or substance of human rights 3 shifts in their scope, ratione, persone, and loci, and 3 dynamics at the institutional level. There are quite obviously many overlaps and interdependencies, both among these 9 issues and with respect to the topics covered by my esteemed colleagues. I will start by exclusion, however, and disclose why I do not devote a special section to the COVID-19 pandemic. This choice might seem strange, to some even imprudent. Yet in spite of the serious challenges arising from the pandemic for civil and political rights, and in spite of the momentous consequences it entails for the economic, social, and cultural rights of millions of people, I do not expect major structural changes from it as regards the functioning of the international human rights system. This is not to deny that the pandemic and its repercussions may contribute in manifold ways to reinforce and accelerate ongoing processes of human rights erosion and deconstruction, but I do not consider it, the pandemic, to be a decisive factor in itself. So first, regarding the substance of human rights. There can be no doubt that digitization and the many dynamics triggered by it pose a major human rights challenge. The problem already begins with adequately capturing and labeling the phenomenon. Some find it useful to distinguish between digitalization, and digital transformation. The complexity is augmented by the fact that this field is demanding in terms of scientific and technological insight, not a self-evident quality of lawyers, at least when looking at myself. Furthermore, the challenges arising in such different fields as social media, cybercrime, artificial intelligence, autonomous driving, human enhancement, etc., affect a wide range of human rights: privacy, free speech, health, mobility, life, dignity, you name it, arguably leaving no sector untouched. It is important to note, however, that this is not only an area of pitfalls and risks, but also of opportunities for consolidating and strengthening human rights. The second issue I would like to address is climate change. What has been said before also applies here. We are dealing with a complex and truly global phenomenon that affects most diverse features of our existences and thus our human rights. In addition, when I refer to climate change, I use it as a convenient catch-all term encompassing phenomena such as sea level rise, the deterioration of the habitat of fauna and flora, and the consequent loss of biodiversity, overpopulation, rural depopulation, and the ensuing megalopolis growth, we have heard about that in the morning, the rise of natural disasters and migration, and yes, the increased likelihood of the emergence and proliferation of pandemics. It is fascinating to see the great many efforts across the globe to tackle climate change via human rights-driven climate litigation. There are already numerous examples at the domestic level as well as before international courts, and we will see certainly more of that to come in the next decade. At the moment, the applicants are chiefly struggling with obtaining access to their respective fora. To be sure, climate change is a momentous threat to humanity, but its negative effects are diluted in a twofold sense. On the one hand, they tend to affect not only few, but many or all. On the other hand, climate change figures remotely in the chain of causality, with many other factors and actors intervening. This is a challenge for a human rights protection system that is designed to deal with individualized violations of human rights. It is a serious hurdle to establish that, in the context of climate change, a given individual is the victim of a violation of rights that is attributable to a specific state. It will be interesting to see how the complaint of 6 Portuguese teenagers against 33 state parties will fare before the European Court of Human Rights, or its alter ego, a complaint by the Swiss Klimaseniorinnen, Senior Women for Climate Protection, and a very recent complaint of an Austrian suffering from Uthoff syndrome, a temperature-dependent version of multiple sclerosis. Thirdly, we witness a fundamental challenge to the universalist aspirations of the International Human Rights Project. Lofty promises such as all human beings are born equal and free in dignity and rights, or all human rights are universal, appear to be far away at a time where human rights are criticized as a Eurocentric or Occidentalist endeavor or a post-colonial enterprise. The attacks come from too many sides to name them all. Human rights are said to be relative with regard to religious precepts, Islam, US conservatives, or, in a more secular perspective, relative to historical and cultural traditions, Africa, China, but also indigenous peoples in Latin America. Or all at the same time. Just think of the unholy alliance of the Russian government and the Russian Orthodox Church for the protection of so-called traditional values. Calls for pluralism and exercising in identity politics, commendable and reprehensible motives lie close to each other in this debate. In a similar vein, techniques developed in international human rights law to accommodate such claims for diversity, for instance, reservations to human rights treaties, or the doctrines of proportionality, here it again, margin of appreciation or subsidiarity, are ambiguous. They can both be used to strengthen and weaken human rights. The battle for the integrity of the Human Rights Project is far from over. On the contrary, it remains one of the chief tasks on this decade's human rights agenda. Let us next turn to challenges arising from shifts in the scope, ratione personae and loci of human rights. As concerns the beneficiaries or right bearers side, being human rights, they are evidently focused on the human person, more precisely on the individual human person. While the debate on collective rights, people's rights, third-generation rights, and so forth is anything but new, today there are calls to extend the personal scope of application of human rights even further. It is telling that the respective proposals are often linked to challenges that we have already identified as relevant at the substantive level, digitization and climate change. Let me only point to the multifaceted debate on the anthropocentrism or speciesism of human rights law. A growing number of scholars seek to advance human rights in an eco- or biocentric perspective towards animal rights, plant rights, or even rights of nature as a whole. Just think of the concepts Latin America, Pachamama, Sumac Causai. In a similar vein, in view of the digital revolution, others call for extending human rights to artificial intelligence or robots. The challenge in all this is to find the right balance between, on the one hand, keeping the Human Rights Project inclusive, faithful to its emancipation narrative, and on the other hand, avoiding dangers of erosion due to the inflation of human right bearers. Similar considerations apply to the converse side, the addressees of human rights. While international human rights law has always focused on the state, non-state actors are more than ever before identified as systemic risks to human rights. Armed groups, terrorist organizations, the mafia, transnational corporations, social media companies, etc. The horizontal effect of certain human rights is increasingly accepted both in domestic and EU law. At the level of international human rights law, duties of business actors have so far been limited to soft law instruments such as the Ruggie principles. Yet, initiatives to institutionally capture at least the most powerful private actors are on the rise. Also here, a differentiated assessment is necessary. What is to be gained from the formal extension of addressees of human rights obligations, but also to what extent such moves carry risks of dilution of responsibility and accountability. No doubt, also in 2030, the state will continue to stand in the arena as both the greatest protector and the greatest threat to human rights. The focus is also on the state in terms of human rights scope ratione loci. A state is primarily bound to respect human rights within the confines of its territory. Yet, there is now a long-standing tradition, doctrine and practice of extraterritorial application of human rights. That is, however, fraught with many ramifications and also certain inconsistencies. We should expect the pertinent challenges to further rise in the decade to come. This is due to the growing importance of activities of states beyond their international borders, be it on the high seas, for example in the context of migration, labor rights, exploitation of natural resources, and environmental pollution, be it by creating twilight zones between states under the guise of migration management, be it by engaging in military or undercover operations on the territories of other states, more and more frequently amounting to outright situations of occupation. In some, we witness a growing number and variety of zones that cannot be linked for human rights purposes to the state under whose sovereignty they fall. While there is no compelling need for international human rights lawyers to go down the road of Foucault's biopolitics, or more recently, Member's necropolitics, the increasing pressures arising from the proliferation of extraterritoriality have implications for the architecture of the human rights system as we know it. And we have not even touched upon the extraterritoriality challenges in the cyberspace context. Finally, allow me to make 3 short remarks concerning institutions, 1 in a horizontal and 2 in a vertical perspective. Finding the right balance in the separation and interaction of the legislative, executive, and judicial powers is a never-ending mission. The rise of courts, notably constitutional courts, in the protection of human rights has become and remains a characteristic feature of the separation of powers doctrine in this field. Parliaments have even become used to abstain from exercising their powers in view of controversial social and ethical issues, and thus to leave the decision to the judiciary. Abortion, same-sex marriage, medically assisted reproduction, assisted suicide, you name it. Courts willing to receive the past can face major difficulties in terms of democratic legitimacy. These are even exacerbated to the extent courts are ready to enter the business of protecting economic and social rights by substituting themselves to the discretion of the legislator. Another noteworthy feature in the horizontal relationship of powers is the proliferation of and increasing reliance on soft law instruments emerging from the machinery of international organizations, which is also due to the growing difficulty for states to agree on new formal instruments of human rights protection. While this can offer welcome opportunities to specify, adapt, and progressively develop human rights, the lack of public debate in the domestic fora and formal parliamentary approval may add to the perceived and real lack of democratic legitimacy of judicial decision-making, notably at the international level. This takes us to the vertical perspective, and first to the interaction between the national and the international levels. Since long, we can observe a certain asymmetry between relatively well-established substantive human rights standards on the one hand and the weakness of the institutional system of international human rights protection on the other. This will not substantially change within the coming decade. Of course, in the European context, we can refer to the European Court of Human Rights as a noteworthy exception. But even the Strasbourg Court is not free from and immune to pressures and hostilities from outside. The huge caseload has led state parties to devise problematic strategies for resource and docket management that have massively reduced the court's accessibility. At the same time, the court has, on the whole, managed to maintain its integrity and effectiveness and remains to stand as a powerful example for the feasibility and benefits of international human rights adjudication. As regards, finally, the vertical relationship between universal and regional human rights protection, one should not realistically expect major institution developments at the global level within the next 10 years. Thus, regional human rights institutions will remain in the driver's seat. In addition to the already mentioned European Court of Human Rights, this brings the Court of Justice of the European Union to the fore, which seems eager to sharpen its profile as a human rights court, at least in certain fields and in certain ways. There are also promising signals from the inter-American system. Much harder is it to assess how regional human rights protection in Africa and in other regions, Southeast Asian states, the Arab world, will evolve. But next to many reasons of concern, there are signs of hope and in any event much potential waiting to be realized. In various areas of international lawmaking, multilateral cooperation seems to work better now at the regional than the universal level. For example, with respect to trade agreements, I think we'll come to that point later. And one should not underestimate positive effects that may spill over from other sectors, such as, for example, investment law. We have identified a sufficient number of counteracting and confusing dynamics to qualify the narrative of crisis as the most appealing one. However, as crisis discourses can produce, or at least reinforce, perceptions of impotence and paralysis, my preference is the narrative of ambition. This is not so much a call for human rights activism, but a plea, an exhortation of sorts for academic ambition in the sense of a proactive, engaged reflection on human rights. In my vision, this does not primarily mean to devise ever new human rights or novel institutional arrangements, but to explore even more thoroughly and with stronger commitment the premises and implications of the political, economic, social, demographic, ecological parameters within which the human rights project operates and evolves. This analysis and the conclusions to be drawn from it are markedly different from those of the 1990s, but nothing forces the conclusion that it needs another generation for the human rights project to thrive. Thank you.